We are live. Welcome to our community. We're going to do a live broadcast to assist you with some details on how to draft the document. If you go to our channel, if I can go to our channel, okay, you'll see the playlist. And on the playlist, you see where it says Eagle Legacy Estate Court. These type of documents will be provided to assist you with drafting your own documents, or you can, for example, if you have someone else draft your documents, you can kind of use this as a guideline to see if your document includes enough details. I forgot what you would call that. But anyway, you could use the information provided in this broadcast to help you critique your documents before you send them off. If you've already sent documents and you come across this video or any others where you notice that perhaps your documents or letters for demand did not include enough details, that's okay. You can send another letter and include those details and include requests for information, for further information, and so forth. You are allowed to send as many, I won't say as many documents as you need for discovery, but you are allowed to send more documents purpose for discovery. Okay. And it would be wise to include a statement with those documents that clearly states that you're sending the correspondence for the purpose of discovery. Okay? So you'll see that wording or details included in the document that we're going to be using for the demonstration. It's a real demonstration. Welcome. The chat is open. I'm not sure if I can see the chat questions or whatever, but the chat is open. Okay, we're going to get started with the reading. We're going to let the...
Terrace Johnson, POA. Attorney in fact for Terrace Yvette Brown. Current address of authorized party. Notice to Attorney General. CC.
Okay, at the top here where it says current address for authorized party, that would be the area where you would put your address or mailing return address. Okay, so I did not want to divulge my personal information online, so I just typed that in there, but that will be filled in with my personal information um, before it's, of course, sent off. Um, Also notice that this document will be sent to the Attorney General. Um, and that is mainly because um, I have already sent documents to the company and they've ignored it, the documents. I've uh, given several verbal requests, and that is what prompted me to um, write things down, you know, and sent them a letter, a cease and desist uh, notice. And I sent them a handwritten notice, and I hand delivered it. Um, and so they kind of backed off from acting out for a while to just hope that it would just go away, but they did not respond to any of the notices that was given to them. So we're gonna uh, send this to them again, but we're gonna also CC. We're gonna tap in the Attorney General and the Consumer Protection Bureau um, as well. This complaint will most likely be filed with the Better Business Bureau too. All right. Okay. Okay, and I'm gonna put the tracking number on there. Um, Now we can continue on from here. Let's start at the word notice. Notice.
Notice to Attorney General. CC, Consumer Protection Bureau. CC, Better Business Bureau. Delivery of this document shall be performed via a U.S. Postal Service certified mail tracking number. 2. Extra Space Storage. Legally Responsible Agent. Extra Space Management, Inc. Forward Notice to Legal Department/Account Services. Headquarters Address 2795 East Cottonwood Parkway number 400, Cottonwood Heights, Utah 84121. Formal demand for transfer of principal's interest and refund of unearned interest. Account No. Please provide documentation of intra-office account numbers in return correspondence. Principal, Terrace Yvette Brown Johnson. To whom it may concern. I, Terrace Brown Johnson, and the duly authorized attorney in fact, acting under a valid power of attorney executed by notary, employed by Bank of America, N.A., by and between Terrace Yvette Brown, Principal, granting me full authority to act on the principal's behalf regarding financial, contractual, and secured credit transactions, which preclude authority in all matters concerning the above referenced account. Enclosed herewith or previously provided is a true and correct copy of the executed power of attorney authorizing my authority to administer, negotiate, demand, settle, transfer, and otherwise act in all matters relating to the principal's financial interests and secured credit accounts. This correspondence shall serve as a formal notice. According to 15 U.S.C. Section 1615, A, I am requesting the immediate refund of unearned interest for my pre-computed consumer credit account that was paid in full at the inception of application of consumer credit. The principal interest and contracted utility bait and switch tactics disparage the consumer with enforcement of undisclosed liens.
Okay. Oops. Okay, we're gonna just let it read out, and then I'll correct the statement. Utilizing bait and switch tactics to disparage the consumers with enforcement of undisclosed links. Okay, now that's worded properly. Okay, let's go back. Um, I will say this. Um, when you're drafting documents, you want to make sure that you are using legal terms, but you also want to make sure that um, it makes sense. It's simple to understand. Don't assume that the judges or mediators, whoever will be reading this, uh, understand uh, what some judges call legal mumbo jumbo. Okay, because they don't want to hear that. They don't want to have to decipher. They don't want to be a cipher. They want to hear the case. Um, they want to hear the facts. Um, I didn't put in here a lot of facts concerning the emotional distress because that will be apparent in the fact that um, when the statements of facts are presented for the courts, uh, specifically concerning remedy, uh, though everything will um, be based upon uh, the numbers. Okay, and so um, I did not put any uh, emotional triggers or information about, you know, uh, my, the damages of my emotional state due to uh, their actions. Because right now, this document is solely dealing with the facts of the case that is relevant to pointing out. Hold on. What did I do? I was trying to make that font bigger, but select all. Okay. Ah, select all. Okay. Now, now that we have made the font bigger, okay, awesome, awesome, awesome. Um, that's another thing. Um, I'm not sure what the font size is for federal court, but I will tell you this, that your font size does have to be large enough, I should say, for federal court. It has to be a certain font size. It has to be printed from one page side of the page to the other. So many um, points from the edge, and there is a what they call a format that uh, the documents need to be written in, and this document is formatted similarly situated according to that. um, those rules because this is a federal case. And um, so I would encourage you to find out uh, and be aware of what type of case you're dealing with so that when you do draft your documents that you draft them accordingly um, and include uh, the information that is required by the rules of procedure. There's a rules of procedure in courts that govern the documents, the procedure for submitting documents, and how it should be formatted. You see here it says enclosed herewith or previously provided is a true and correct copy of the executed power of attorney. Okay, this correspondence shall serve as a formal notice according to 15 USC 1615A. I'm requesting the immediate refund of earned interest for my pre-computed consumer credit account that was paid in full at the inception of application of consumer credit. Um, the principal interest and contract um, the Okay. I bet y'all wondering like what in the world is going on. I see y'all see me typing shit. Y'all see me typing. I'm pecking away. Um I did use AI to initiate this claim as far as I gave it instructions as to what I wanted to say, but now I am filling in the blanks, so to speak, because the AI just gives you like general little statements and stuff about what they think about what you asking them. And so um, now I'm customizing it with details that I am aware of, and that's the thing about documents um, of this kind. Details are very important. So using a template or something is just not feasible if you really want remedy. It's just not good to use templates. Um, Sometimes people use templates and they have information in there that's not even applicable to them. And you can tell they use the template because the information is misplaced or it's not very detailed um, as to, okay, what specifically occurred in your case. All right. Now, in my case, um, these people employed the bait and switch tactic and all other types of deceptive trade uh, practices. And so, although they violated in other ways, um, I have decided to um, home in on the deceptive trade practices aspect of uh, my case. And it's not a case until a formal um, complaint has been drafted. Um, but nonetheless, the case does begin, as I've told you all before, the case begins out of court. It doesn't begin in court, it begins outside the court whenever the offense or wherever the offense occurred. Okay. That's another thing. This document is missing. Um, and that is because, as I said, I'm filling in the blanks with some details of what occurred as I go along. Um, let's go back up. So, That sounds better. Let's read it again. Okay. We're going to go back. Okay. Wicked. I keep saying we're going to start over and then start editing again, don't I? Because, okay. The reason I keep starting over and editing, okay, for anyone who's just now um, tuning in, understand what's going on in the broadcast. Thank you for the like. Welcome. Um, we're gonna go ahead and get the reading going. Okay, but that is the reason why we are um, proofreading and editing and um, critiquing the document. Make sure we are clear and concise with our requests and for information. Right here, where it did say RE, which is abbreviation for regarding. And instead of putting RE, I chose to write the word out so that it's very clear what's going on in the document. Um, what else did I just edit? Um, right here where it says Contract E requests Extra Space Management Inc. to provide documentation of intra-office account numbers and return correspondence. That is very clear to understand. They need to put the account numbers for all the accounts because it's more than one contract, so that we can have the account numbers for the record. Um, some things people may say, oh, that's self explanatory, but it's not. Because I have given them, I have requested information before, and they keep giving me the runaround. So, since they keep giving me the runaround, and don't want to give me no documentation. I'm making sure that everything that I've already requested that they refused to provide at this point is a refusal because it's been over a year. Um, that it is in writing, very clear and concise what I'm asking for, so that any authorities that can see what the request is that it's lawful for me to ask uh, to request this information, and they are required to provide the specific information that is requested. And I am also giving them some background on what his prompt. Welcome, 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 welcome. Oh, we back in. Okay, I had a few comments. Welcome. I can't see the comments. I apologize, y'all, but I can't see the comments. They need to do better with that. But we're gonna go ahead and to be continue this. All right. Starting at regarding formal demands. Demand.
Regarding formal demand for transfer of principal's interest and refund of unearned interest. Account numbers. Contractee request Extra Space Management, Inc. to provide documentation of intra-office account numbers in return correspondence. Principal, Terrace Yvette Brown Johnson. To whom it may concern. I, Terrace Brown Johnson, and the duly authorized attorney in fact, acting under a valid power of attorney executed by notary, employed by Bank of America, N.A., by and between Terrace Yvette Brown, Principal, granting me full authority to act on the principal's behalf regarding financial, contractual, and secured credit transactions, which preclude authority in all matters concerning the above-referenced account. Enclosed herewith or previously provided is a true and correct copy of the executed power of attorney authorizing my authority to administer, negotiate, demand, settle, transfer, and otherwise act in all matters relating to the principal's financial interests and secured credit accounts. This correspondence shall serve as a formal notice. According to 15 U.S.C. Section 1615, A, I am requesting the immediate refund of unearned interest for my pre-computed consumer credit account that was paid in full at the inception of application of consumer credit. The contracts referenced identified as principal interest. Extra Space Management, Inc. is an account management company that handles the affairs of Extra Space self-storage facilities, also legal recognized as a public contractor. This correspondence has been written with the intended purpose for further investigation.
Okay. this thing annoying. It just don't.
The contracts referenced identified as principal interest. Extra Space Management Inc. is an account management company that handles the affairs of Extra Space self-storage facilities, also legally recognized as a public contractor. This correspondence has been written with the intended purpose for further investigation into the matter, due to fact that this company has infringed on public trust, utilizing bait and switch tactics to disparage the consumers. Extra Space Management has unlawfully procured property by enforcing undisclosed liens without proper notice in compliance of Property Code Rule 59. The consumer has hand-delivered notice of breach and demand to cease and desist. The contractee captured evidence of the delivery of the notice during business hours to the office on location 5811 North Houston Rosslyn property. Due to the overwhelming evidence of neglect that had already been demonstrated, the contractee felt forced to invoke higher authorities to mediate this preclude genuine issues, depository, pending further investigation. The contractee
gonna reword that, but on my own time. Now let's just go ahead and see what the documents say. I am a perfectionist. I'll keep editing.
Depository, pending further investigation. The contractee has video evidence of some of the events that occurred in retaliation.
Let's start over. Let's see. Right here, yes.
The contracts referenced identified as principal interest. Extra Space Management Inc. is an account management company that handles the affairs of Extra Space self-storage facilities, legally recognized as a public contractor. This correspondence has been written with the intended purpose for further investigation into the matter, due to fact that this company has infringed on public trust, utilizing bait and switch tactics to disparage the consumers. Extra Space Management has unlawfully procured property by enforcing undisclosed liens without proper notice in compliance of Property Code Rule 59. The consumer has hand-delivered notice of breach and demand to cease and desist. The contractee captured evidence of the delivery of the notice during business hours to the office on location 5811 North Houston Rosslyn property. Due to the overwhelming lack of action in good faith that had already been performed, the contractee felt forced to invoke higher authorities to mediate this matter. There are genuine issues of material depository pending further investigation. The contractee has video evidence of some of the events that occurred.
Let's go ahead and see how it reads. Let's go right there and see what it's, how it's reading. The read through smooth.
This correspondence has been written with the intended purpose for further investigation into the matter, due to fact that this company has infringed on public trust, utilizing bait and switch tactics to disparage the consumers. Extra Space Management has unlawfully procured property by enforcing undisclosed liens without proper notice in compliance of Property Code Rule 59. The consumer has hand-delivered notice of breach and demand to cease and desist. The contractee captured evidence of the delivery of the notice during business hours to the office on location 5811 North Houston Rosslyn property. Due to the overwhelming lack of action in good faith that had already been performed, the contractee felt forced to invoke higher authorities to mediate this matter. There are genuine issues, depository as material facts, pending further investigation. The contractee has video evidence of some of the events that occurred in retaliation to the initial complaint of rat infestation and request for documentation. The failure to act in good faith is an expression of neglect that exposes deceptive trade practice on a corporate level in the business practices of Extra Space Management Inc.'s evident in their business activities. Cited authority: USC Commercial Code Sector 17.12. Deceptive advertising. A. No person may disseminate a statement he knows materially misrepresents the cost or character of tangible personal property, a security, service, or anything he may offer for the purpose of 1. Selling, contracting to sell, otherwise disposing of, or contracting to dispose of the tangible personal property, security, service, or anything he may offer, or 2. Inducing a person to contract with regard to the tangible personal property, security, service, or anything he may offer. B. No person may solicit advertising in the name of a club, association, or organization without the written permission of such club, association, or organization, or distribute any publication purporting to represent officially a club, association, or organization without the written authority of or a contract with such club, association, or organization, and without listing in such publication the complete name and address of the club, association, or organization endorsing it. Statement of facts. Extra Space Management Inc. has violated USC Commercial Code Deceptive Advertising. Sector 17.12. A. To the letter. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, that Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented the cost and character of tangible personal property. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, that Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented by the fact no disclosures were provided to allow mutual contract with consent derived from meeting of the minds. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented right to interest that was not waived. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented a security interest. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented everything they offered by failing to disclose standing liens placed on the principal's property without notice. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Management Inc. disseminated statements it knew materially misrepresented the purpose of selling, and lack of disclose the purpose of the contract to sell. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented otherwise disposing of property to continue to contract under deceptive trade practices. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented contract terms hidden from plain sight. I attest, from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage acted in dishonor to dispose of the tangible personal property of the contractor's security and internet by the refusal to disclose the information when asked. I attest, from first
I heard some more errors, but I just let that pass. But that one was too. That one was too egregious. I had to do something about that. All right. Crap, what did I do?
I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements. It knew materially misrepresented otherwise disposing of property to continue to contract under deceptive trade practices. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented, contract terms hidden from plain sight. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage acted in dishonor to dispose of the tangible personal property of the contractor's security and interest by the refusal to disclose the information when asked. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements. It knew materially misrepresented the contract which indicated several agreements were being made with a person undisclosed. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, Extra Space Storage Management Inc. disseminated statements it knew materially misrepresented to contract with regard to the tangible my personal property. I attest from first-hand knowledge of the facts and offer
Ah, ah. There you go. The complete name and address was on the note. Okay, y'all. If y'all following along, y'all see how this goes. I just keep going back and forth. Not back.
I affirm in fact asserted as truth, the blue bonded paper, I perceived by sight and affirm with first-hand knowledge, the instrument was a check, drafted to Bank of America, which may be considered a publication of financial instrument, due to the fact the instrument included my full identity, complete name and address with an endorsement on it. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, the instrument was a fictitious instrument and the endorsement on the check was forged. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted, the financial instrument had the words and format, payable to, great value storage, the previous name of extra space.
This thing doing the most, man. Oh, man. Hold on. Let's get it. We're going to go back up to 20 and start over and see what it sounds like. Hey, what's going on? How y'all doing? Why did I say I proceed with first-hand knowledge by sight? Because there are different ways that you can be a witness to something. And so I wanted to be clear that I did visibly see the change that I'm speaking of. If they drafted on my account without my permission. And I kept asking them questions about that. Oh, they skipped right over that. They wouldn't answer no questions that day. this turns out. Alright. But, okay. So far we got about 27, 28, 29, 30 statements of fact. We embarking upon what, 31, 32. Ah, ah, I'm getting tired. I'm gonna take my ass. Okay. I hate when I'm trying to scroll to something and just keep scrolling. That ain't what I'm trying to copy. No way. This is. Okay. Now, why am I changing this? Because seeing it in this way is makes the information clearly depository as statements of facts and evidence. Okay, here we go.
Policy officer offered his personal assistance in militarizing his badge of authority to deprive me of liberty and acted adversely, disregarding due process and employing phishing tax acting under color of law. He was told he was in vitiation off protocol prior to any harm.
Oh, this thing is doing them all.
In fishing for a reason to cause me further harm. He said you insinuated that we were racist. I defended the accusation with the facts I know to be true. I never mentioned race to him. I said the police have a tendency to be against me, and made it clear that I was speaking in reference to the fact that he was adjudicating a civil matter on the scene, which I had experienced several times prior to his addition to the precedents of abuse of authority, retaliation, deprivation of human rights. He became very aggressive, stuck his foot in the doorway, and mental subdued me without a warrant to enter the space or procuring cause. Acting under color of law, he proceeded to tell me I can't enter the unit without him, which he well knew was against protocols. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted. The policy officer offered his personal assistance in militarizing his badge of authority to deprive me of liberty and acted adversely, disregarding due process and employing phishing tactics acting under color of law. He was told he was in violation of protocol prior to any harm. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted. The City of Houston policy officer deliberately executed an illegal eviction under his personal capacity. I attest from first-hand knowledge of the facts and offer as truth of the matter asserted. The officer seemed to conspire with the operator to execute the adverse possession. I cannot verify that he paid to muscle me, but I can say by first-hand knowledge of how I was treated, I perceived that he may have been paid to do all the extra stuff he did. It may have been an independent malicious act on his part alone because even his partner did not seem to want to contribute to his offense. The officer who was committing the offenses seemed to have some financial interests in executing an illegal eviction as a standard practice under the table dealings. Description of contracts referenced in this correspondence. Contract listed as Unit 59C. And contract listed as Unit 61D. We are unsure of the unit title or documentation transfer. That may have occurred on the 5 contract units invested at the Antoine location. Some of the contracts mentioned due to change of ownership during the contract performance period. Instructions. Instructions are provided below regarding the above-referenced secured credit accounts. You are hereby directed and instructed to immediately transfer and release all of the principal's right, title, interest, equity, and beneficial interest associated with the secured credit account to the principal. The documentation provided is evidence of the full transfer of possession to the lawful designee identified as Power of Authority, Terrace Johnson, POA, attorney-in-fact. FIA request for information. Extra Space Management Inc. is requested to conduct a full accounting of the account. At arm's length include the following. Provide legal documentation of principal balances on all accounts, include both North Houston Rosslyn property as well as Prevent 9 US 5 units at Antoine location. Accounting ledgers must clearly identify interest charged, interest accrued, and fees assessed. Note, this is a formal request for a refund of all payments received and refund of any and all credits, offsets, reserves, or proceeds associated with the accounts referenced in this FOIA request. Instructions. Refund and remit all unearned interest, overcharges, excess finance charges, improper fees, and any amounts collected beyond the lawful principal obligation associated with the account. Cease any further collection activity under Color 9F law, deceptive trade practice, and cease all unlawful, false, or adverse reporting affecting encumbrance or impairment against the principal. All associated accounts are pending completion of the accounting and transfer process. Provide written confirmation within 10 business days from receipt of this notice confirming compliance to SEC regulated FOIA request, Federal Open Information Act, request for information. Provide documentation confirming the transfer of interest has been completed, as requested. If you have legitimate questions concerning this matter, you may contact us in writing. Documentation is expected to be provided in clear and concise form and in layman's terms, legible in the English language. This is a formal request for information for verification the accounting has been performed. Description of proper legal response to FOIA request. Documents provided in response to this request is expected to be performed by authorized party, signed affidavit under oath. All rebuttal or inability to comply with the written request for documentation must be addressed by statement of facts. If no response is given to remedy the breach of contract, we will remand this complaint to the proper authorities, who may deem an action to be considered as willful neglect. The relator has specific request for information related to the accounts and included a statement of fact, precluding a further investigation into the financial record keeping involved. All documents should include relative details to procurement of interest. Account documentation request certified business records admissible in a court of record, as such in a court of competent jurisdiction. Attention. Opportunity to cure. Instructions concerning accounting records highlight the sections that provide information on the refund amount due to identify what has been calculated, and all documents should include the date drafted. Please provide the date payment shall be remitted. Pay to the order of Terrace Brown Johnson. Herein call the loan due and owing in arrears of an uncertain amount TOB date determined by discovery and depository evidence. This legal demand is made pursuant to all contractual obligations, agency authority, under the executed power of attorney, applicable state and federal consumer protection laws, USC 16.15 commercial law principles. This correspondence has been performed to execute fiduciary duties in good faith and fair dealing to allow an opportunity to cure claim of conflict of interest by the consumer. The relator herein give notice to the trustee or agent responsible party / of Deceptive Trade Practice Act that regulates secured financial accounts and Truth in Lending Act which govern lending transactions. Failure to comply with this lawful demand may result in additional administrative action, formal complaint with consumer protection agencies. We reserve the right to seek compensation via civil remedies, claim of tort for the actions of your operators who performed an illegal eviction several times, unlawfully executed, April 12, 2025, causing harm on my person and property. We demand equitable relief to be made whole.
Okay. I believe I have edited quite a bit. Okay, we're gonna end the reading right there because um, one, I keep editing and editing and editing and editing, and sometimes when I'm drafting documents, I like to just back up off of it a little while and allow my mind to clear out so that I can um, come back at it fresh. Thank you all for joining me in this broadcast, and we will be doing some more document oriented uh, sessions.